Yeah.
Are we ready to start? Good afternoon. Thank you all for your patience. I'm so sorry that we are late getting started. You know, the best of intentions with technology. It worked 15 minutes ago, and then at noon it stopped working. So thank you all for waiting patiently. We are now ready to begin. Thank you very much for joining the Public Interest Law Section's presentation on fair housing law with Amanda Biondo. Oh, I knew I was going to mess it up. I'm sorry, Amanda. Biondolino. So Amanda is a member of the SAS Law Firm in Tampa, Florida, and she brings a strong background in litigation to her law practice. She has litigated disputes in state, federal, and administrative fora on a wide range of employment matters, discrimination in housing, and places of public accommodation, and commercial litigation. Amanda graduated with honors from St. Louis University School of Law and is admitted to practice law in Florida, Missouri, and Illinois. In addition to private practice, she's also served 2 years as a human rights attorney for the Missouri Commission on Human Rights. So we have a very qualified and exemplary speaker with us today to teach us more about fair housing law. Thank you very much for joining us. And without further ado, I'll turn it over to Amanda.
Okay, well, thank you very much. Hopefully everyone can hear me okay. If you cannot, send a chat message and let me know. I will try to get through this presentation in the next 50 minutes, which I should. If anyone has any questions, please feel free to send them in. You do not need to wait to the end. We may parse through them and answer some sooner rather than later, but please do send in any questions that you have. So our objectives today are to gain a better understanding of state and federal fair housing laws. We'll talk about the scope of the protections, different theories of liability if you have a case you're thinking of taking on, the administrative process that is available to all complainants, and then private litigation. There are a lot of laws that cover fair housing issues, discrimination in housing. The main laws will be the Federal Fair Housing Act, and then here in Florida, the Florida Fair Housing Act. The two laws are substantially equivalent, I would say nearly identical, and federal law will be instructive for any case, even if you bring it under the state act. There are additional laws here in Florida. There is a Service Animal Act that is worth looking at. There's no private right of action there, but there is some housing protections for individuals with service animals. And a lot of these other laws are mainly for those housing providers that receive federal funds. If they receive federal funds, they're subject to a plethora of laws. You'll also see on here Americans with Disabilities Act. That would cover the parts of the complex that is open to the public, such as a leasing office, or if any of the amenities happen to also be open to the public, those communities need to be aware of the ADA, and individuals who are using those amenities just as customers, not as residents, would then have the benefit of the ADA. So as you can see, federal, state, and even local laws protect people from discrimination. If you have a discrimination issue in whatever county that you're in, it's worth taking the time to see if there's a local law that you can rely on. In my experience, if you have someone who is looking for a quicker resolution, they just want their parking space, or they just want this issue with the service animal or emotional support animal being addressed. In my experience, the local jurisdictions, the cities who have ordinances and have commissions or committees or departments within the local government who enforce and investigate these, they have, I would say, I don't know, better relations, but a more direct relationship with the people in their community. So sometimes if it's just a matter of getting those accommodations is a really applicable one, it's sometimes best to go straight to the local if you have a client that you're trying to assist. I always put this warning on because everyone's doing Google research and everyone looks at the ADA when they're looking up discrimination claims, and it's a disability issue. So if it's a disability issue and it's a housing matter, make sure to keep that in mind and don't simply rely on ADA law, because ADA is covering employment and places of public accommodation. And even when you see tenant landlord being discussed, that's typically commercial landlords and tenants, in strip malls, things like that, who has responsibility for what, and they're talking about the ADA. So I think the Fair Housing Act is much more accommodating. So I have had attorneys tell me, especially when I worked at the commission in Missouri, um, the ADA doesn't say I have to do anything for that person. The ADA doesn't say I have to give them a parking spot. And that is true because the ADA does not cover housing, but they need to be considering the Fair Housing Act and what does the Fair Housing Act require. The Department of Justice and HUD do put out a lot of good guidance. And at the end of this PowerPoint, and I'll share this PowerPoint with you, I'll send out the slides after this webinar. And I also have an outline that has what I use to prepare for this. There are a lot of resources that the Department of Justice and HUD will put out. So those are what I would look at. They're very straightforward and easy to understand for the most part. And if something is in there, in that guidance, for example, the joint statement on reasonable accommodations, and they'll list a bunch of scenarios. If a scenario is in there and in that guidance, the Department of Justice and HUD is saying that is reasonable, typically that is what the commission will certainly find reasonable, the Florida Commission on Human Relations, and it's very instructive if you're in litigation. So diving right in, the Florida Fair Housing Act, like I said, is substantially equivalent to the federal Fair Housing Act. So that basically means it covers the basic protected classes that we're all probably familiar with: race, color, religion, sex, national origin, disability, familial status, association. If someone is being discriminated against because of a friend or family member of a protected class, they also have protection from those adverse actions taken against them. And then, of course, retaliation. And again, always put on here, check your local jurisdiction, because the locals really typically have more protected classes because they can tailor those more to what their constituency will pass and approve of. And it's harder on the state and even federal level to get additional classes inserted into the law. For the most part, the protected classes are very straightforward. I mean, it's race. So it's either any race. It's not just a minority race. So if a person is being discriminated because they're white, it's covered. Black, it's covered. Any other race. They go, both ways, so to speak. Same thing with any religion. Both genders goes either way, although you might typically see one versus the other. Realize that they generally cover all races, all genders, all of that. The two that are a little trickier are disability and familial status. So individuals are protected under disability discrimination laws if they either have a physical or mental impairment, which substantially limits one or more major life activity, or they have a record of such an impairment, or they're regarded as having impairment, even if they don't. So if a landlord thinks someone, has HIV, for example, they get nervous, they don't renew a lease, or they evict someone, even if that person doesn't have that impairment, they still fall under the protection of the law. You'll notice that individuals without disabilities aren't protected. So that means you will see communities designed for individuals with disabilities, and someone without a disability can't, file a complaint or a lawsuit because they weren't allowed to access that housing. It doesn't go both ways, is how I describe that. Familial status is another protected class. It's a little more nuanced. It's not included in the ADA or employment discrimination laws, but it protects families with children under the age of 18. So if you have a family and there's children under the age of 18 and they're getting some type of adverse action taken against them because of these kids, they would fall under the protection of the law. It could also be a designee of the parent. It could include someone who's pregnant. A family can be an individual under fair housing law, but it has to be connected to that child under the age of 18. So could be pregnant, could be in the process of securing custody of someone under 18. If you have a 19-year-old child who's still living at home, you're not going to be able to assist them. Adult children living at home, you're not going to be able to assist them. It's under the age of 18. Now, who can file a complaint is very broad, and it's easy when you're thinking of, okay, the individual who was evicted from their apartment. Of course, an individual who has an adverse action taken against them can file a complaint. There just have to be an aggrieved person. They've either been aggrieved or they either have been injured or they believe they're about to be injured by discriminatory housing practice. Other types of complainants include testers. So in housing, there will be testing that can be controversial. Some people really push back against the testers, but testing is something that housing providers do have to worry about. And honestly, when I look at testers, when housing providers fail the test, they've probably told that same information to I don't know how many other individuals who've inquired about housing. Typically it's a service or support animal issue, and you'll get a test. Well, someone will start asking, can I bring my service animal? And they'll say it's a pets only property, so no. And then they fail the test, and then they can get a complaint filed against them by the tester or by the typically it's a fair housing organization, or there are different organizations who do this type of testing. And the purpose there is the tester can file a complaint, and then there's also that damage to the public that the housing organization will file on behalf of as well. Now, that organization, you'll see them listed, they can file complaints. They have to show a damage to their organization, a diversion of their resources, or a frustration of their mission is what you'll see they need to show. But fair housing organizations certainly can file complaints, and they do. Cities and municipalities have filed complaints. Developers can file complaints. They see housing developments that they're trying to have approved, particularly multifamily apartments, and they have difficulty getting those approved if it's for a discriminatory reason based upon a protected class of who people believe, or it is actually intended to be designated for people of a certain protected class. If the pushback is because of that protected class, they could file a claim. And it's really not limited. It's only limited by someone who claims to have been injured by a discriminatory housing practice. Now, dwelling is pretty broad as well. It's easy when you're thinking of, an apartment or even a home. Of course, that's housing, but it could also be an assisted living facility, a group home, dorms, vacation home, extended stay hotels, shelters, homeless shelters. Now, once you start moving away from the traditional home into facilities such as a homeless shelter, it gets more difficult to show that they are, in fact, a dwelling under the Federal or State Fair Housing Act. But if it's a place where the individual intends to stay and intends to return, then that will lean that decision more towards it being housing. If it's a structure that's intended to be occupied by one or more families as their home or the place where they stay and they return to, it's a dwelling. And you'll see in here, even vacant land can be considered a dwelling if it's intended to have a dwelling constructed on it. So a lot of land use decisions and even lending issues come up with vacant land, and they can still have a claim under fair housing law. And then the same thing with potential defendants. It's basically anyone who has control over the dwelling. So typically you'll see landlords, rental managers, the property owners, but it can also be condominium associations and HOAs. It could be real estate agents, banks, developers, builders will have liability, and even cities will have liability. If they have control over the dwelling and they're making an adverse decision against someone based on a protected class, they could face liability. And there's individual liability under fair housing law. So the actual landlord is named, not just the management company. The individual gets named as well. So it can put some pressure on potential defendants when you are asserting a claim against them. Oh, go ahead.
Sorry, Amanda, we have a question if you don't mind.
No, go ahead.
Do you know of any jurisdiction that has added economic status as a protected class, i.e. a low-income household as defined by HUD?
That use their income level as a protected class?
That use economic status as a protected class.
Yeah, I've not seen economic status as a protected class. I'm not saying that doesn't exist in some local jurisdiction. I'm not aware of it. And typically when you see the Fair Housing Act described, it's people have the right to live in the house of their choosing that they can afford. So typically you have to be able to afford that. You can be priced out of it as long as everyone on the open market is being, the housing is being offered at the same price to everybody. But what you will see sometimes is source of income as a protected class. And when you get into the Section 8 or the housing choice vouchers, that can get tricky. And some courts will include that within a source of income. Some cities will actually state the voucher is included within the source of income protection within our ordinance. And so that could be something to consider and look. But again, it's typically as long as the price is the same for everybody on the open market, price and will not be considered discriminatory. And so how much the family makes it may or may not be considered. I would say always check your local ordinances because they're typically much more liberal than the federal and state law. So what is prohibited? I always say it's basically any bad decision, adverse decision that has to do with housing. And it's extremely broad. So what you see mainly is a refusal to rent or sell, or you'll hear terms and conditions. So any discrimination on getting someone into the housing. So during the application process, during a test, during a purchase, something along those lines, getting into the property is certainly protected activity. So you got to make sure that their protected class isn't being used to disqualify anyone. And then there's also the terms and conditions of that housing. So sometimes there's a bit of an overlap, but terms and conditions, I generally, in my mind, look kind of after the sale. And how are the rules being applied to people? How are the eviction procedures being applied across the board? Is there any kind of harassment going on? It could be sexual harassment. It could be harassment based on any protected class. It's not always sexual harassment. And I've seen more and more disability-related harassment where either the landlord or the property manager or even tenants are harassing other tenants based upon disability. That could be a protected, that could be prohibited under the law and actionable as well. It's important when you look at the, I would say with harassment, when it comes to sexual harassment, you have this quid pro quo harassment. So certainly when it's, if you perform this sexual favor for me, I will give you a break on your rent. Something along those lines. I'll fix your air conditioner. Whatever the trade-off is, that is always prohibited. When it's just the ongoing harassment, nothing really being traded, but the person is making the housing basically intolerable, it's the hostile environment threshold. So when has it been severe and pervasive enough to create a hostile environment? So keep that in mind when you have a harassment claim. When it comes to the rules and procedures, look how everyone else is being treated as well. When you have an eviction, sure, they might have a rule. The rent, if the rent is late on, it's due by the 5th. If it's late, you get a notice on the 15th. We're going to start evicting on the 30th. And this particular individual, their rent was late. They never brought it up. On the 30th, they're getting an eviction notice. That individual might have that rule applied to them strictly, but when you start looking at how other tenants are treated, and is everyone getting the same late notices, and is everyone getting evicted on the 30th, you might see that they're not applying the rules and the procedures even-handedly. And it's hard for tenants to know that because the rules are written and they see that they didn't follow the rule. And so they might think, I deserve it, or it's appropriate. If there's any question, I would always tell someone to file the complaint. With fair housing law, probably more so than any other law, you have agencies whose sole purpose is to investigate these complaints. You have HUD and you have the Florida Commission on Human Rights. You have local commissions, like you have the Pinellas County Commission, and I'm probably botching their name, but you have these commissions who that's what they do. So if an individual feels, I was evicted, I don't think it's right, I don't have the smoking gun, I'm not sure, but I think it could be my race, I think it could be my gender, and I see other people doing the same things that I did, and they don't face the same consequences. They should go ahead and file that complaint. And the commission will investigate that and determine, they'll look at everybody's, they do a interview, they do a file review. It's much more thorough of an investigation for those of you who've dealt with, say, an EEOC or an employment discrimination. The fair housing investigations that HUD does and that HUD requires its fair housing assistance partners to do is much more thorough. So they will look at all the comparators and see, is everyone being treated the same? Was the eviction rule enforced the same way? And if person 1, 2, and 3 was not evicted, but person 4 was, and that's our complainant, what's different about them? And when you start seeing patterns of, non-disabled tenants are given a pass, but this person was evicted outright at the first opportunity, you could have a circumstantial case. So I always say if someone is uncertain, that it does not hurt to go ahead and file that complaint. And if you get someone questioning you about that, you don't necessarily have to take that person on as a client even, because the individual can file that complaint without an attorney. So as long as that person, you direct them to the commission, let them know that resource is there, they can make that call. They can go online. However, that particular commission will take complaints, and they can get the process started. And I think the commissions are all very helpful in that regard about getting the complaints intake completed and processing. So there are, interesting developments in how far the parameters of the Fair Housing Act go. A recent case. Now, this was withdrawn, so everything that I say on this has kind of been erased, but maybe not. But there was a case involving tenant on tenant harassment. And can a landlord be responsible for tenants who are harassing other tenants? And most landlords will say, I can't do anything about that. That person has whatever, it's freedom of speech, or I don't control them, and that person's doing what they're doing, but the landlord's not taking any adverse action. So the landlord feels they shouldn't be held liable. But there have been cases where the landlords have been held liable for failing to intervene or to take any action when there's tenant on tenant harassment. And in my personal experience, I've seen it disability related. And why didn't that landlord take any action? Especially in a rental context, you have a lot of rules that these tenants have to abide by. And they can only put certain stuff on their front door, and they have to pick up after their animals, and there's noise, and they're getting all kinds of rule violations. When you have a landlord who's saying, well, I can't do anything about tenant on tenant harassment, they probably could have done something. And I always, when I look at a claim, I think of the same um, type of, I guess, evaluation you might do in the employment context. What did the employer do when they knew or should have known? Did they take prompt and appropriate action? I think of those types of questions. I consider that a landlord certainly doesn't have control over other tenants like an employer has over its employees. But there could be something there depending on the facts of the case. So it's worth looking at and seeing what is going on in those particular communities. Different examples are listed here. There could be issuing and enforcing notices to quit, threats of evictions, enforcing evictions, some kind of notice. I know in some cases there's typically some kind of intent or some kind of involvement by the landlord that's not exactly right. So in my experience, the cases that have gone forward really have had something more than just tenant on tenant harassment with nothing else there. Either the landlord is somehow involved or the landlord is turning a blind eye because they're related to the harasser. But it certainly could be where the landlord is doing absolutely nothing when it could be doing something. And in their practice, you look at what they do in other instances. Well, they could have certainly done something here. What that is, that would be maybe for the jury to decide. But this particular opinion was withdrawn recently and without comment. So I just say stay tuned. We'll kind of see what happens with the tenant on tenant harassment as applied to a landlord. Now I believe I have a slide later on talking about, can a tenant sue another tenant for interference with their housing? And well, here it is. Can a plaintiff sue a neighbor? So a plaintiff can sue a neighbor. There's under the retaliation provision. It's typically just called retaliation, but it is more than just retaliation. It's coercion, intimidation, threats, or interference that are prohibited when they're based upon a protected class. So what's that threshold that a tenant has to meet to be able to sue their neighbor who is, yelling racial slurs at them, trying to, intimidate them, insult them, the whole spectrum? It seems to me that it has to be pretty egregious conduct for a court to allow a cause of action by one neighbor against another neighbor. I mean, you'll see the case have been allowed were basically threats to kill someone, a firebomb, of course, like why that, of course, would be intimidating and threatening and drive someone out of their home. But it almost has to drive someone out of their home to be of that level. Certain just indignant, like it's not a civility code. You might see that in employment context. So people treating each other badly, even if it's based on a protected class, that would be a tough claim. But depending on the severity, I would keep an open mind, and it could be that a plaintiff could sue a neighbor given the appropriate facts. And like I said, there's lots of other practices that are discriminatory, misrepresenting the availability of housing, which is as simple as, someone walks in and says, do you have any apartments for rent? And based on their protected class, the people say, no, we don't. And then you'll see that a lot in testing. And whether it's racial testing or disability testing, people will say, no, I don't have anything. And then another person will come in of a different race or without a disability. And yes, we do have these apartments available. Or here is where we have an apartment when someone with a disability comes in. But when someone without a disability, they have many more options available. Um, that is misrepresenting availability of housing. That's also what is typically called steering, when you're steering people towards a particular unit. I see mostly that happening with disabilities. It used to happen more with race, could happen with any protected class. But I've had in my experience someone say, well, these units are already accessible. So another tenant already, put a ramp in here. So here's the unit for you. And meanwhile, there's 3 or 4 other units available that they didn't show. That's steering someone to a particular unit based on their protected class, or steering them away from other units based on their protected class. I've had landlords put in an email, my property is not suitable for someone with a disability, and they just don't understand that they don't get to make that decision. If the individual wants to live in that housing, and they can afford to live there, and they meet the non-discriminatory terms to the rental criteria, then they can rent it. I've had people say, well, the second floor isn't safe for someone with a mobility impairment. It's just not. What if there's a fire? I've had these conversations. Um, and I tell them, you don't get to make that decision. You don't get to limit the housing that people are shown because you fear or you think that that's not the best housing for them, or you're afraid of what liability, you're afraid of some liability that might happen if there's a fire and they can't get out. I mean, these are all the concerns that housing providers have said, and they really aren't defenses. You simply cannot steer people away from all the available housing. Um, I've seen, of course, discriminatory zoning restrictions. Those sometimes are easier than others to prove, but you'll see that a lot with group homes, even where you can't have group homes so close to one another, and they're really those are designed based upon the individual's disabilities. Um, Depending on those, there could be an issue there. Block busting, when you get those postcards in the mail that says, certain people are moving into your neighborhood, you want to sell now while the getting's good, you can get a good price, that is prohibited, and that is called block busting. Redlining and reverse redlining. I've had a case like this. I had a good case, but it was untimely. But that's where, and I typically with borrowers and lending, where they will take a map, and draw a red line around an area and either say, we're not going to lend in this area, which is redlining, or you might see it where we're going to target this area with predatory terms. And if it's based on a protected class, because that's typically a minority neighborhood or maybe religious, concentrated of a particular religion in an area, whatever it is, if it's a protected class, then it's illegal. I always say being, like a slumlord's not discriminating against everybody. They're treating everybody just as bad. And predatory lending is generally not discriminatory because everybody is getting those terms until you link it to a protected class. And a lot of times you do that by reverse redlining because they're targeting certain communities. And lots of advertising heavily. The wording of the advertising indicates it. So there have been some cases under those theories of recovery. One that you see, well, I see a lot, and typically it's added on. It's rarely a standalone claim, but sometimes you will see them as a standalone claim. But discriminatory ads and statements, even the statements that the landlords and the property managers and anyone with, I would say again, control of that property, the things that they're saying and the ads that they're putting out indicate a preference or a dispreference based on a protected class. And it's an ordinary listener standard, which I consider a pretty low bar, and it's really a question of fact. So these can be problematic for housing providers to deal with. But when you see advertisement for active, older adults, well, what does that mean? Does that mean someone with a mobility impairment wouldn't be welcome there, wouldn't fit in there? I don't know. No kids. That's like you see that all the time. A sign that says no kids. Cannot do that. That is a blatant violation. Unless an exemption applies, you cannot say that with housing. Um, Mature applicants only. That was a case involving a college town. And so it was a question of, is it saying mature applicants only, meaning like not wild, college kids? Or is it saying mature like we want, 55 and older? We want this to be a retirement community. So basically no children under the age of 18. And I believe that was a question of fact. Didn't, made it past summary judgment. Once you have to start explaining what you mean by something, it's a problem. And what that has the effect of it is pushing people away. People aren't responding to those ads because of what they say. Next to a certain religious institution, so it's a synagogue or a mosque or a cathedral. If you're next to many, you can say that. But when it gets to be where you're really signaling to the reader that this is a Christian community or this is a Jewish community, then other people might not feel welcome there, and an ordinary listener would say, there's a preference against them. And so same thing, photos, symbols, anything that's indicating a preference. I've seen ads that say no foreigners, and the provider tried to explain away and say, well, I meant no scams. The scams that you get, it always involves sending money to a foreign country. And I said, well, you didn't say that. You said no foreigners. And so now individuals, based on their national origin, are thinking, well, I shouldn't apply there because she only wants people who are born in this country. And that's a problem. So the statements and the ads and the statements being verbally made when people are looking at properties. I've had people say, oh, well, your kids are going to tear up these floors, really complaining about the kids. Well, that tends to drive a family away. They think their kids aren't going to be welcome there. It's not going to be worth the hassle. So keep in mind all of that when you're evaluating a claim like this. So I have like 13 minutes left, and I'm on slide 16, so I got to kind of hurry up. But interesting study, Facebook. You probably have seen it in the news. They have a very interesting and involved advertising platform. There is, I believe, it's still going on, a HUD complaint against them. They had another complaint. I believe National Fair Housing Alliance, but I could be wrong, that settled, but HUD is still pursuing them based upon their involvement in allowing people to target their ads. And they put protected characteristics in there, so that's kind of problematic. Another thing to think about, and I've seen this a lot in new communities, there are design and construction requirements for multifamily properties built after March of 1991. And if you think of the very basic mobility requirements, think of what someone in a wheelchair would need to just basically get around this place. That is what is required. So a person with a wheelchair basically needs to be able to get out of their car and get to all the common areas and get into their apartment. They need to be able to move around in their bathroom. They need to be able to move around in their kitchen. And they need to be able to reach the light switches, outlets, thermostats. You'd really be surprised by the number of communities that are built that have steps everywhere, like 1 or 2 steps everywhere. And they're beautiful and they're landscaped beautifully, but they're completely inaccessible to individuals with disabilities. And they're just built out of compliance. And it gets really expensive for someone to have to go in after the fact and make that accessible. But they will have to do that. They'll have to set up a fund, and they will have to make those units accessible. So something to think about. Now, I will say courts may or may not hold a later owner liable. So it depends on the jurisdiction. It depends on the facts of the case when it comes to those accessibility requirements. So if you have a newer 1991 is not that new, but a newer property, keep that in mind and do a search and see what decisions are being made. But then I also say if someone has a problem, it's send them to a commission and file a complaint, and they'll be able to figure it out pretty quick if they've got a valid complaint or not. Individuals with disabilities also are entitled to reasonable accommodations and modifications. Accommodations are changes to rules. Modifications are changes to the structure of the property. So there's no magic words. If they communicate that they need something because of their disability, then their landlord should be engaging in an interactive process. And I'm just going to kind of go through these pretty quick to kind of get through the majority of these slides, and I'll give you these slides. But the landlord should either be granting those if they're necessary, or if they're skeptical, they should be engaging in some kind of interactive process. And they need to give them unless they are an undue burden, or they are a oh, now I'm having a mind blank, but they change the typical like services that they provide. If it's something new that isn't the typical service that this housing community provides, such as, they don't provide shuttling back and forth to the grocery store, and you want them to now do that. Well, that's a fundamental alteration in their program. That might not be reasonable. But if it is something that they provide, then, and you just need it altered somewhat, or a change in a rule, like a change on when someone's rent is due, when their Social Security check comes, not on the first of the month, but the fifth. Should they be getting charged a late fee every month? No. Ask for an accommodation from that rule, and something like that should be granted. If they need a parking space assigned to them, or maybe there needs to be more accessible parking. Parking spaces are a common concern in multifamily property. And then, of course, service and support animals are more and more coming up as complaints when people are being denied service and support animals. I will say that the Fair Housing Act is very accommodating, and there's no limit on the type of animal. Doesn't have to be a dog. If it alleviates the effects of their disability so that they can, live better in their home, they're probably going to be able to get that service animal or support animal, and it would be allowed. And they can't be charged an extra fee, and they can't be forced to obtain additional insurance, and the animal might not even need to have training. I'll provide you with an outline that I have with certain cases that I typically rely on, but I just feel that fair housing law is pretty accommodating, and any refusals need to be based on objective evidence, that and criteria that's evenly applied. Saying a property is a no pets property, but allowing a service animal would be a fundamental alteration of that. That's not going to fly. That is absolutely not going to be a defense to a service or support animal request. These are the defenses. I mean, undue financial burden. I like when housing providers say it's an undue financial burden, because then that's a question of fact about how much money they have. And so, and how much, research have they done to figure out that financial burden? And typically, it's very speculative. Same thing with the direct threat to the safety of the individual or others. It can't be based on fear or speculation. It really needs to be based on objective evidence of this particular animal, and not based on, categorical criteria like breed bans, things like that. Now, this is probably something to keep in mind when you have a fair housing case, is there are a lot of exemptions, and they're technical. So you really need to just take a look at it. But single family exemption, single family homes, people are allowed to own up to 3 single family homes and, rent those out, and they're not going to be subject to fair housing law. Once you kind of get the fourth, then you're kind of the big dog and you're going to be subject to the law. Religious groups, private clubs get exemptions. Again, housing for older persons can keep out kids. So familial status discrimination does not apply if they meet the criteria, but they still, under housing for older persons, they do have to, they cannot discriminate against any other protected class. Miss Murphy, that is if you have like a 4-family flat, for example, it can be up to a 4-family flat if the owner lives in one of them. So think of a duplex, think of a triplex, or a 4-family where the owner of that property lives in one of the units. That unit will be exempt. And then there's certain ways to become exempt from the design and construction requirements. So I got like 5 minutes left, so I'm going to kind of go through the rest of these really quick. We talked about examples of overt discrimination. I talked about other circumstantial claims, typically called disparate treatment, where you might not have the smoking gun, but other people aren't being treated the same. So you really got to take a deeper dive and see how people are treated. Fair housing law also allows for disparate impact. So you might have a neutral policy or procedure. One that was typically used as a criminal history ban. Criminal history is not a protected class. Maybe in some local jurisdictions they've added it, but it's not. But if you can link that to a disproportionate impact on a protected class, then you might have a disparate impact claim. There is a robust causation requirement. So they're not easy cases, and they're very statistics oriented, and you really have to show the impact. But if you have such a case, it's worth, and depending on your resources, you might want to submit that to the commission, because that could get pretty expensive to pursue. But they have been pursued. Typical disparate impact procedure is, once you make that initial showing, the housing provider can provide a substantial, legitimate, non-discriminatory reason. And that's going to be pretty, I consider that pretty broad. They just have to come up with something. And as long as it's somewhat reasonable, and is applicable, then they will meet their burden. And a plaintiff then must show that that business interest can be met by a different practice with a less discriminatory effect. For example, a blanket criminal history ban might be a violation, but if you had a more tailored policy, that would allow more individuals to access that housing. So in the next few minutes, I just want to let you all know that, complaints can be filed with the Florida Commission on Human Relations here in Florida, or HUD, or any local commissions. You must file those claims within a year with these entities, or they won't have jurisdiction. Now, with Florida's Fair Housing Act, you do need to exhaust. So there's different opinions on it, but basically the case law is saying, as written, you have to exhaust. So if you want to file and stay in state court, you need to make sure to file timely. If the timeline is missed to file with HUD, you can still file in federal court without going through HUD. You don't have to exhaust under the Federal Fair Housing Act. You can file your complaints different ways. These are what I would say you need to make sure that you have a covered activity, and we'll leave you probably here, a covered activity. So there has to be discrimination due to a protected class. General bad treatment or unfair treatment that's not related to a protected class does not fall under the fair housing laws. So they have to be able to make some link to the protected class. You want to make sure you have a covered respondent. So if you have a concern that a respondent might be exempt, you just look through the exemptions and see. You need to have a concrete injury. Individuals are a piece of cake. They would always be definitely injured if they're subject to an adverse action. but these organizations need to be able to show an injury if they want to proceed. And then you got to make sure you meet the timing requirements. So go through here. So, and just to kind of give you a taste of what you might be able to get out of it, of course, injunctions. There can be actual damages, punitive damages under fair housing law, and there are fees for successful claimants. So you can win an award of your attorney's fees. And there are also civil penalties that housing providers may face under both federal and state laws. So there are some significant penalties that may be applied, but the attorney's fees provisions are very helpful to individuals to get some legal help getting their claims handled, because the dollar amount for the claim, may or may not be very much, but there is the fee provision for a successful complainant. And this finally is just a list of what I consider good guidance from HUD, and also some of these are joint statements from HUD and the Department of Justice, but answer a lot of fair housing issues. So I have 1 o'clock right now, which I think is all the time that we have. So I appreciate everyone's time. I haven't got any questions, so I hope people do have questions, because we hardly touched on anything.
Who is the burden of violating the FHA on, the plaintiff or the defendant?
The burden's going to be on the complainant to show it. Basically, at all times, the burden will be on the complainant to prove the discrimination.
Okay, thank you. And I don't think we've had any other questions, but thank you all very much for attending. Again, apologies for starting late. If you are not already a member of the public interest section, we would love to have you join. It's one of the least expensive sections in the bar to join, and it's a great group of people doing important public interest work. So John has put up the link for you to be able to join, $35 a year. And he's also put up the CLE information for you to be able to get CLE credit for today's presentation. And we will be sending out Amanda's PowerPoint to everyone who attended as well. And thank you very much for joining us today. Have a good day.
Thank you, everyone.